Good afternoon, everyone. Thank you, Lindy and Tracy. Um, Let me introduce myself. I'm Videsh. Uh, Videsh, the National Vice President of SAIBD. Um, that's the South African Institute of Building Design. By the way, for those in the architectural profession, this talk and a few other talks over the expo are CPD Category 1 accredited. So, with that in mind, doing presentations and providing CPD is not my full-time job. I do have I'm actually employed full-time by a large multidisciplinary company. But my expertise is architecture, engineering technology, and law, or more specifically, the building law and standards. And that's why the topic of today is the duties and obligations under Act 103 of 1977. That's the National Building Regulations and SANS 10400 suite of standards. The correct terminology is the deemed to satisfy standards. With that in mind, I'm going to start sharing, and we would have enough time at the end of the session for Q&A. So for those that are logged in, you can type in your Q&A in the comment chat, and you all can engage with me after the presentation. So now sharing the presentation itself. So, what are the duties and obligations, and who do these obligations and duties fall to? And to answer those questions, we need to understand law, regulations, and standards, and the hierarchy of the law, regulations, and standards. So, a lot of people, even administrators like building inspectors, for example, sometimes think that a standard is a law. It's not. So this deemed to satisfy standards, which is SANS 10400, are standards that, if applied, would be the simplest solution to comply with the law. That's literally what it is. The regulations come from law, and they are quantitative. So laws are qualitative. What do you want to achieve? That's what the law will literally state. How to achieve that in quantitative terms is normally written down in a regulation. So that's how it normally works. So the hierarchy is laws over regulations over standards. Now, while we called this presentation or this talk today the duties and obligations, remember that every line of the Act
Hi, Videsh.
imposes
Obligations
and rights to different parties.
If you can put your presentation
And if
on
we have
full
to
screen,
discuss
that would be great.
every mandate, obligation, and right, this is going to take a few days to discuss. So today's discussion are going to be a few pertinent points on these mandates, obligations, and rights. what I've done is chosen a few pertinent points that seem to impose red tape from administrative side, and we know that red tape is a bad thing. Red tape leads to a downturn in the economy, etc. A few of the obligations that the owner and or the professional seems to overlook. So I'm going to go through those rights and obligations since we only have a limited time today. We also need to understand what are the purposes. So we've discussed hierarchy. We need to understand the purposes. And for that, I want to go through the history. So the earliest written code in relation to the built environment is the Code of Hammurabi, written roughly 1770 before current era. And the point I want to make is that the objects of the code, that's what, just under 4,000 years old, has not essentially changed. So some of the things, for example, or let's just say the equivalent that is contained in the modern codes have been written down roughly 4,000 years ago, and that hasn't changed. So a performance-based standard, which is literally from the Code of Hammurabi, is build strong. A building practitioner's disciplinary scheme, where it says a builder shall be slain, and a consumer protection scheme, where the builder shall replace all that is destroyed. And literally, these three ideas have been carried forward since then. The thing is also that while it is the earliest written code, these or some kind of code or regulation has been in existence from almost the earliest time that man started changing the environment. This picture at the bottom here is older than the Code of Hammurabi. There must have been some kind of code or understanding between the different people involved in the construction and occupation of that building. So it's not something new, it's very old. So what are the purposes? And on the right-hand side of my screen, I've got the hierarchy, you've got the law, then the regulations, then the standards. So the law is basically stating the objectives in this triangle that we see, the objectives and functional statements. Why does a law exist should be written into the law, what it's trying to achieve. You then have performance requirements, and those functional statements are basically written into the regulations. And lastly, you have the solutions, which is written into this into the standards. That's the bottom level of the triangle. There's generally two methods of the solution. One is the deemed to satisfy provision, which is SANS 10400 as a deemed to satisfy minimum standard. There are alternative solutions, and those alternative solutions are rational designs, for example. Before we go on to those obligations, law is difficult to understand. It can be interpreted in different ways. So to implement the regulation or a standard, you need a guidance. The guidance normally comes in a part of the act called the preamble. Now, the preamble basically explains the reasoning for the enactment of the Act, and its objectives is, or the objective of the preamble is to aid in the interpretation of the ambiguities. It should include its purposes, its aims, and its justification. The purposes, aims, and justification will help you understand and interpret the Act and what you're trying to achieve in compliance with the Act. So, with that said, I've changed slide to show you the contents. And the thing is that the please share the screen. I am sharing. I hope my screen is now visible. It's just that I cannot see the presentation myself. I'm using a single screen. So DMG, you can contact me via messages and just tell me if something is not right with the screen share. I'm coming back to the contents. What we notice is that there is no preamble. It is. I must stop sharing and present again, maybe. So where is the preamble and how do we understand what the code is trying to say? I want to the contents goes right up to a number 34, and no, there is nothing, there's no preamble. So how do we understand this Act? And well, the simple answer is it's in Regulation A and SANS 10400A. We'll get to that part just now. All right. What I've done here is point out the different regulations. There's 21, and there's one new one, 22, that still has to come. It's a future one. So there's 21 regulations. And for these 21 regulations, we have a SANS code. Yeah, stop. It is presented. Stop sharing. Hi. I do hope that you all can see screen. I believe that there is a problem with my presentation.
On the orange tab. So you just breaking up. So on the orange line.
All right, so I hope that screen is better. I do apologize for this. This is the first year we're doing a live, or should I say a webinar type expo. So all of these acts and these regulations and standards give citizens, owners and professionals and the local authorities rights while imposing obligations. I included owners and professionals because it's normally the professional that represents the owner in up to occupation of the building. So I'm going to hop in a little bit with, or almost straight away, should I say, not a little bit, but what are these obligations and who do these obligations belong to? And I'm just going to go with certain parts of the Act. As I said, I'm not covering every obligation. So Section 4.1 of the Act basically gives an obligation to the owner in that all buildings require an approval, an application and an approval before the building can be erected. So that is an obligation by, or an obligation imposed on the owner. For Section 4.4 of the Act, any building built without the application is a contravention of the Act. So that gives rights to the municipality and obligations to perform duties to the owner. These are quite easy, and I think most of us actually understand those. There are some that are not as easy to understand. Section 7. Section 7 of the Act is a bit of a controversial one because it is the only part of the Act, if you can see my pointer, this AA, AAA, BBB, and CCC are subjective matter. Every other part of the Act and regulation is objective. So this gives an obligation to the municipality, that is, to adjudicate their application based on subjective matter. I need to point out here that the definition of local authority is a group of people or a board of people that represents the municipality and not a single person. This is quite critical because of the subjective matter. We cannot have a person deciding or making a decision on subjective matter, because then it will be biased in favor of the way that person thinks, for example. Okay. So Regulation A1. Regulation A1 gives an obligation to the professional. And I'm not going to expand on all of the obligations that the professional has, but basically point out this, which kind of summarizes it. It's A11 of the regulation, or Regulation A, which is the design, planning, and supervision of the building is to be carried out by an architectural, engineering, scientific, and or survey professional. Basically, any construction, you would need an architectural, engineering, scientific, or survey professional involved. Except for the minor building works, there are those minor building works. I'm not going to, due to time, I'm not going to concentrate on it too much. And there are also exempt buildings. The exempt buildings that are exempted from the Act, still require professionals. The only exemption is the municipal exemption for plan approval. Some other pertinent aspects to point out: there are restrictions to the municipality also. For example, bylaws in terms of this Act. So you can have bylaws, but in terms of Act 103 of 77, bylaws do not exist. So your application cannot be judged or adjudicated in terms of any bylaw. If a bylaw is contrary or imposes a greater imposition to the owner in terms of that building, that bylaw, in terms of this Act, cannot exist. So the municipality must not look at that and therefore still approve your plan. If it is compliant with the rest of, or it's compliant with Act 103 of 77. Other municipal restrictions, there's time limits on when an application or when the response from the municipality has to be done. Now, the thing is, the Act says the local authority. It does not say traffic department or sewer department or health department. It says the municipality. The municipality is holistically viewed as the whole department. Therefore, there are regulations going or responses from the local authority within the 30 days that says no response from sewer department. Now that is an abrogation of their duty. They have to respond holistically within the given time period. The owner's restriction is that they have to get an occupation certificate or consent from the local authority prior to occupation. So occupation without authority is an offense. Okay. I'm going to hop, while we're talking about occupation, there is what I consider red tape. Literally, there are 3 conditions to be met. After plan approval and building construction, there are 3 conditions to be met for the local authority to issue a completion certificate. It's a right of the owner and an obligation by the municipality. Those 3 conditions are basically electrical, structural, and fire protection or fire installation systems, the certificates for these. All right. The reason I speak about this is that certain municipalities impose much more conditions. And remember, I said earlier on that there is no such thing as a bylaw for Act 103 of 77. So those extra conditions, or what I consider red tape, should not be applied by the municipality. What about additions and alterations? A lot of people ask me these questions, and there's, for example, a person in a high density or a middle income area wants, due to expansion of his family, adds a bedroom or a bathroom, and the municipality wants to apply the whole of all the new regulations or new standards to the whole building. That maybe I should say, before I even say it's wrong, we need to understand the act, and that's why the preamble is so important. What is the act trying to achieve? So how must it be interpreted? Therefore, how the act must be applied. Annexure B11 in particular is very relevant to additions and alterations. So we're going to quickly go to B11, and this is a copy and paste of Annexure B11 of SANSTAN 400A, obviously. What I've done is I've highlighted some key terms here. The first one is that the building regulations are not retroactive in application. You can't ask the owner to retrofit the existing building to meet the new standards if the building was approved. In the case of an addition, you can treat the new portion as entirely separate and therefore leave the old portion of the building the way it was and treat the new building as in terms of the new regulations. And that's relatively easy to do. In the case of an alteration, it's never easy to do. And the guidelines, this I'm reading is a guideline published in terms of the Act. It's very clear here. It becomes necessary to ask to what extent that part of the building which is not to be altered should comply with the national building regulations. This question must be asked by the owner, the professional, and the municipality. This obligations are to all three. This is actually very important, especially pertinent in the application of fire regulations where escape routes are required, because suddenly those restrictions or those regulations are much more stringent. So the advice given in this preamble is that a pragmatic and practical approach is necessary by all involved, by the way. Again, it's not only to the owner. This is, in essence, also to the municipality. What is important is that every attempt shall be made to ensure the safety and health of all occupants of the building, but it must be within the context of what might be practical and economically sound in an old building. I've highlighted the next sentence there. That's if an owner or entrepreneur cannot alter a building to suit his purpose at a cost which will enable him to to have a reasonable economic return, he will probably not alter the building at all. This will lead to the perpetuation of a situation which might be dangerous, but one which is compliant with old bylaws or regulations and thus perfectly legal. Such a situation could often be considerably improved by making certain changes that are practical and economically sound, even though they would not provide the same standard as would be expected in a new building. This is so important because I've dealt with a lot of boroughs or local authorities throughout the country here. And almost all of the BCOs or plans examiners are quite adamant that they do not consider what is economically sound. Whereas the Act is adamant, or the guideline of the Act actually drives that home quite well, that they have to look at what is economically sound. So I think that's a very important obligation to the municipality and the owner and the professional. The key words in the last paragraph is actually quite nice. It says both the owner, well, normally it's the owner and professional because the professional is representing the owner, and the local authority have to consider what they are trying to achieve with the regulations. And that answer must be tempered by the knowledge of what is reasonable and practical to require of an existing building. This here is so important because, as I said, most BCOs, plans examiners, professionals don't seem to apply this recommendation or this preamble of the Act. A other obligation that most people don't seem to apply is that as soon as you change the occupancy of the building without changing the building itself, so most people think you haven't changed the building and therefore you don't need to make a plan application. But as soon as you change the use of the building, you need to make a new application. So you cannot change a D1 factory to a J4 warehouse, talking about not altering the building. You're just changing the use of it. A new tenant, for example, you would still need to make a plan application for it. I think this is a very important part of the Act because a change of use imposes on the health and safety of the occupants of the building and the neighborhood and on the municipal services. So quickly, I'm trying to allow for some Q&A, so I hope I'm not rushing through this too much, but we're going to go through some of the takeaway lessons. Why are these obligations overlooked or ignored? Well, why is this so? These can be sometimes attributed to the ignorance of the owner and or professional, because the professional is representing the owner. It could sometimes be the failure of the professional being unprofessional because he doesn't know. Sometimes these can these ignored obligations can be attributed to the lengthy approval process. I've touched on that, with the red tape, and the local authority is insisting on non-mandated onerous requests. I was trying my best not to touch on this topic, but corruption, and I'm just going to throw it out there that maybe there is, maybe there isn't. I don't have proof. I've had my own experiences, but it is something that needs to be tackled. We need to remove corruption. And lastly, sometimes these can be attributed to unprofessional registered persons. And to solve that problem, CPD, continuous education, whether it's in the form of CPD offered like this, or the paid for ones, or at ALSs, etc. That is so important to the registered professional. Obligations to the owner. Only start construction after the building plan has been approved. There is a method, and you can apply for early construction. There are parts of the Act that allow for the owner to apply for that. Okay. Do not occupy a building without an occupation certificate, and that the use of the function of a building cannot change without a new building application. Do not rent out an office or factory or low-risk warehouse as a high-risk warehouse. that is what I'm, or that are the obligations of the owner, some of the major obligations of the owner. Professionals, please inform the owner of their own legal obligations, and not informing that owner of the legal obligations is a contravention of the Architectural Code of Conduct, in my view. I'm going to ask also, or should I say, now that we've discussed pre-construction phase, the application, what about post application? So post construction, should I say? What happens? You need to apply for a certificate of occupancy. I'm just going to quickly point out this problem, and then hopefully we can go into the Q&A. There are literally 6, if not less. It depends if it's applicable. But these 6 items that are required by the local authority prior an occupation certificate can be issued. It could grow longer, and I say it could grow shorter. Depends which is applicable, and it could grow more depending on how many Form 2s were signed. I've just been informed that my slideshow is kind of stuck at page 10. I'm not too sure why this is happening. I will just swap the view back to just a normal PowerPoint. I do have a very high up and download, so I don't think it's an internet problem. So I apologize for that. I think DMG would make this slideshow available to their attendees. For those that missed or didn't get all of this, I do apologize for that. Maybe someone can just inform me if it's still stuck on slide 10, or am I now on slide 28? That's what I should be on. So there's literally 18 slides that
Hi, Videsh.
were missed.
The slide is now perfectly fine, and we will be sharing it after the
Okay,
presentation.
thank you so much. All right. So, sorry, I need to catch my thoughts again. So very quickly. Yes. Okay, thanks. I did get that. Thank you so much. Okay, so I was at literally slide 28 there, showing the 6 legally mandated or required items that the municipality or the DCO has to ask you prior to occupation certificate. With that in mind, a lot of the municipalities now are asking for these items. A certificate from the architect for roof insulation, a glazing certificate from Saga, surveyor certificate, ITC certificate, separate engineering certificates for different elements, water department certificate in terms of a bylaw, and etc. These items are not a requirement by law. They are red tape. They should not be included as a part of the requirements for an occupation certificate. What does this cause, or what problem does it then put forward? The problem is that the owner cannot occupy his building legally. The thing is, he cannot, or if he does occupy the building, he's then illegally occupying a presumably compliant building, because a glazing certificate is not to show whether the building is compliant. An engineer certificate for any glazing above 10 meters is a requirement, not an ITC certificate, not a SAGA certificate. So in essence, the building is compliant if an engineer was involved as required in terms of Form 2, but the SAGA certificate is not. So therefore, the building inspector is now making the owner illegally occupy a building when the building is compliant. The next thing is that the banks would hold the final draw on building loans. There's a loss, therefore there's a loss of income, or you can't then rent out that premises, and therefore loss of income. This causes stagnation in the development sector, and especially now with the COVID lockdowns and the fact that with the violence and all the burnt buildings or destroyed buildings in KZN and Gauteng, we cannot afford this stagnation. So that's an important one. Before we go to Q&A, you have earned 0.1 Category 1 credits. The VA is a South African Institute of Building Design. You will get this slide. I've obviously attributed where I've got a lot of, number one, the pictures, the text, what's not mine, and or what informed my decisions on the presentation here. So that's the end of the presentation. I'm going to stop sharing now, and I can then look at the Q&A and if there's any questions. So Tracy or Lindiwe? Okay, Tracy has a question that she's put up from one of the attendees. When applying for a certificate of occupation, please confirm where we can find the fact that only electrical, structural, and fire certificates are required. That's in, and just off my head, Section 14 of the Act. I can kind of look for it and kind of confirm it, but due to time factors, maybe, yes, I just looked back at my slide. I didn't open the Act itself, but it is contained in Section 14 of the Act. So that's where you find that. Any other questions or comments?
Hi, Videsh. There don't
Hi,
seem to
Tracy.
be any. There don't seem to be any more questions.
Okay. So I think if I remember correctly, we are at the end. I've taken up the 45 minutes. Tracy? Or do we still have the If anyone wants any more questions, or I don't know, you guide me, Tracy.
Yeah, we do still have a few minutes. So if anybody would like to post a question, now's the time.
I must apologize about one thing about the slideshow, but as Tracy confirmed earlier on, especially those parts that got missed, I don't know whether you'll upload it on your website or.
We will be sending it after, but there are some more questions that are coming through, Videsh. The first
Okay.
one is, has section 14 been raised with Johannesburg building inspectors in a test case?
Okay, I can't say yes or no confidently. I'm Durban based, and I haven't personally done it. I don't know if other people have actually done this or requested that. But I would encourage every person. So if someone who knows these facts and if the building inspector, so you were the professional or you're the owner, and the BCO comes to you and says, please provide me a SAGA certificate, please provide me an ITC certificate. The question to then ask is, ask the building inspector, number one, what gives him the mandate to ask those certificates? Because the Act specifically does not stipulate it, number one, and number two, if it is required, there is generally an engineer. So Form 2, that when you do your application, tells you what is or who are the competent people that need to provide certificates. And only those certificates actually need to be provided. So I'm saying the individual must raise it.
Okay, thank you. And the second question is, do you know, does the agreement SA fit in with SANS 10400?
Yes. So Agrima is one method of compliance. In terms of the Act or the regulation, you can follow the deemed to satisfy standards. You can do a competent person can do a rationale design, or a portion of the building or the whole building, if it is Agrima certified, would then be compliant. And that's allowed for. Agrima normally applies, or just to explain what Agrima is basically if you came up with a totally new solution, there is no deemed to satisfy rules for it. A totally new way of building, for example. You can apply to SANS or SABS. They obviously would ask you for certain studies or tests to be provided to show that it actually complies with certain health and safety rules, and therefore, and then issue a certificate. It's called an Agrima certificate. The thing is, normally new standards get written based on an Agrima certificate. So the first phase of writing a SANS standard is the Agrima certificate. I hope that answered that question.
Thanks, Videsh. And our last question is, the Act still says that it doesn't bind the states. Is this not opposed to the Constitution? Your comments?
That's a lovely question. I don't have a. Okay, I'm not government, so I can't really answer you. But what I can say is that the Act is changing. The Act was written in 1977 or approved in 1977. There are exceptions. Basically, certain buildings don't need to comply with that. That includes government buildings. It includes mining facilities. It includes national key points. Now, the thing is, the National Key Points Act has been withdrawn. Therefore, there is no national key points. But what happens to the old national key points, where plans were never submitted? What happens to railway housing, where plans were never submitted? What happens when you now sell them off individually or need to do additions and alterations to those buildings? Based on time, I'm just going to try to summarize here. It's been about 5 years since the Act has went through the green and white paper stage, if I'm not mistaken. It is currently sitting on the minister's desk. The Minister of Trade and Industries. I know this because I sat on committees to rewrite the code. It's been sitting on the minister's desk now for approximately, I don't know, 3 years or so. But hopefully it gets signed off, and those questions then, the question that you just asked will then be answered. It's only on a rewrite of or adoption of a new code will that be answered. I've just been informed that we are out of time. It's time to wrap up.
Thanks so much, Videsh. It was a really informative session. There were a couple of technical hitches, but not to worry. What we are going to do is we're going to send everyone the presentation again, and the recording will be made available. Thanks again, Videsh.
Thank you. Have a good afternoon, everyone. Thanks.